Real estate disclosure duties for sellers, brokers, and agents. A presentation by Benjy and Benjy Law Corporation. This presentation is not intended as legal advice nor to establish any attorney-client relationship. Rather, this is merely a broad overview of the subject matter intended for educational purposes only. If you believe you may have a claim, you should promptly consult an experienced attorney. Delay may result in an inadvertent waiver of valuable legal rights and remedies. The discussion herein is premised upon California law concepts. For residential real estate sale transactions, California law no longer subscribes to the caveat emptor or buyer beware theory of liability. Rather, the state imposes certain affirmative duties on sellers and their listing agents for purposes of investigation of non-obvious issues such as physical defects to the buyer. For disclosure to the buyer. Disclosures are made in writing shortly after execution of the contract by seller and buyer and prior to the removal of contingencies, certainly prior to closing. This presentation is premised upon the sale of 1 to 4 unit residential properties. There is a statutory requirement that the seller provide a transfer disclosure statement to the buyer as soon as practicable before the transfer of title. This requirement may not be waived and applies even where the sale transaction is deemed by the parties to be an as-is sale. Doesn't matter, you still got to do this. Buyer has between 3 to 5 days after delivery of the transfer disclosure statement to rescind the purchase contract and cancel escrow. In addition to physical defects and malfunctions in the home systems, the transfer disclosure statement must also disclose past or continuing material noise nuisances or other nuisances. So even if it was in the past, even if you think it's over, it may need to be disclosed. The seller and listing agent are under a duty to also disclose material facts affecting value or desirability of the property. Value or desirability are the key terms here, especially where those facts are actually known to the seller or the listing agent, but not known to or within the diligent attention and observation of the buyer. So if the seller or the seller's team knows about it or should have known about it and it affects value or desirability of the property, it must be disclosed, and it must be disclosed before closing in writing. The listing agent and his or her brokerage are potentially liable to the buyer for negative fraud or deceit, which is intentional failure to disclose or misrepresentation concerning facts pertaining to the value or desirability of the property. The listing agent and her brokerage have a statutory duty to conduct a reasonably competent and diligent visual inspection of the property and to disclose material facts concerning value or desirability of the property to the buyer in writing based on that inspection. Please click the thumbs up button and the bell icon for this video. This helps the YouTube algorithm provide wider distribution of this video to other users that may benefit from it. Thank you. Listing agents do not have the following duties. They do not have the duty to inspect or disclose such matters in connection with the commercial portion of a mixed-use property. So if it's a mixed-use property that has a commercial component and a residential component, the disclosure requirements we're discussing today only apply to the residential portion of that property. Nor are such brokers under any duty to the seller to advise him or her of tax consequences in connection with optimal tax structuring, etc. Nor is the listing broker under any duty to conduct intrusive physical testing to determine whether a foundation of the building is sound or not. Nor is the listing broker under any duty to do off-site inspections or to analyze or investigate permits or public records. Seller and seller's listing agent have no duty to the buyer to disclose the ramifications of facts that they do disclose. They just need to disclose the material facts themselves and let the buyer and buyer's agent figure out what they want to do with that or whether they need to investigate it further. There's no obligation, for instance, to disclose that the value of the property may be negatively impacted by the disclosed fact. Rather, they must only disclose the issue itself. For example, a historical noise nuisance, or a death on the property, or a known latent physical defect. And that disclosure should be done in writing and in a timely manner. The seller and the listing agent do not need to take the further step of saying, and by the way, we think this reduces the value of the property by $100,000. That is a decision or a conclusion that the buyer and the buyer's agent can arrive at for themselves. The seller and or listing agent have a duty to disclose the existence of litigation concerning the property. But all they need to do is really disclose the case name, the case number, and the court in which that case is pending. They do not have a duty to furnish the specific details of the claims. However, it would probably be prudent if they had a copy of the pleadings in that case, maybe the complaint or cross-complaint and answer, etc., to furnish a copy. It's not legally required, but it would be wise to do so. Then there's the death disclosure requirements. Where an occupant has died at a residence within 3 years prior to the date of the buyer's offer, this is considered material information that the seller and his listing agent must disclose in writing to the buyer. In addition, unless that death was by virtue of HIV or AIDS, it is required that the disclosure provide a cause of death, for example, suicide, in writing. So the caveat being that if it was an HIV or AIDS death, you don't need to elaborate on that. That's not required to be disclosed. Similarly, if the death occurred more than 3 years prior to the date of the offer, the seller and listing agent are not legally obligated to disclose that information unless the manner of death was such that it was either notorious, such as a murder-suicide, or for some other reason that has tainted the reputation of the property, thereby materially reducing its value or desirability. In that case, even if it occurred more than 3 years ago, you'd want to disclose it in writing. Typically, a buyer must sue the seller and or the listing agent for failure to disclose a material fact concerning the value or desirability based on the following deadlines. 2 years is the general rule from the closing date, where the failure was negligent but not intentional. But in those cases where it was intentionally fraudulent, it would be 3 years from the closing date. Reminder to like and subscribe. If you're getting value from the presentation and have not already done so, please like the video and subscribe to the channel. Thank you. Then there's the seller property questionnaire. While this is not statutorily mandated, whenever a single family sale transaction utilizes the form known as the California Residential Purchase Agreement, that form includes a contractual obligation for the seller to furnish a seller property questionnaire to the buyer. Unlike the transfer disclosure statement we discussed earlier, which happens to be statutorily mandated, the seller property questionnaire is a creature of the form sale contract only. It is not required by statute. The seller property questionnaire guides the seller into disclosing specifics and more detailed information concerning the property and its systems, thereby protecting the parties by ensuring that most material information actually gets timely disclosed in writing. Broker fiduciary duties. Brokers owe a fiduciary duty to their clients. Listing broker owes a fiduciary duty to the seller, for example. Or a dual agent that's representing both the seller and the buyer owes a fiduciary duty to both sides. Brokers' duties to non-client third parties, however, are limited to statutory duties, which include duties of disclosure for facts that would materially impact value or desirability. In instances of dual representation, a buyer may sue the dual agent for both breach of statutory duties and also breach of fiduciary duties. The broker's fiduciary duty to her client requires the utmost good faith and undivided service and loyalty. This duty is in excess of and requires more of the broker. It's in excess of the normal due diligence standard of care imposed on a broker as to her non-clients. This is over and above. Failure of the broker to disclose material information to his client may constitute what's known as constructive fraud, exposing the broker to liability, and this would happen even in the absence of intent to defraud by the broker. So even if it was quote unquote innocent, not intentional, the broker was not trying to hide the ball, because of the fiduciary relationship, a failure to disclose material information would expose that broker to a claim for constructive fraud. Note that most broker misconduct that qualifies for breach of fiduciary duty will also qualify as constructive fraud. Breach of fiduciary duty and/or constructive fraud may expose the broker to punitive damages over and above pure monetary compensatory damages. So if the damages caused as a result of the failure to disclose add up to about $100,000, that would be the compensatory damages portion. There may be an additional $200,000 or $300,000 or $400,000 in punitive damages tacked onto the back of that, where there is a breach of fiduciary duty and or constructive fraud, if the plaintiff can demonstrate a violation of the punitive damages statutes, which requires a higher level of proof. Higher standards apply there. Broker's failure to verify information. A real estate broker cannot accept information received from another person, such as the seller, as being true, and then transmit that information to the broker's client without either verifying it or disclosing to the client that the information has not been verified. Where a broker is in a fiduciary relationship with a buyer-client, she must either independently verify that information or alternatively expressly communicate to her buyer-client that the information has not been independently verified, in which case she would be wise to make that disclosure in writing. And this sort of standard also applies to a person in the dual agent position. Please call Benjy Law Corporation for a free consultation. We offer a free legal consultation with an experienced attorney. This can be done either in person at our office in Beverly Hills, remotely via Zoom or FaceTime, or telephonically. The consultation is free of any obligation and completely confidential and protected from disclosure to third parties by the attorney-client privilege, even if we're not ultimately retained as your legal counsel. To make an appointment, please call us at 310 area code 203-2650. That's 310-203-2650. Or email us at info@benjylaw.com. That's info at benjy like yellow law.com. This concludes this video. We hope you found it informative and useful.